SJC-12747 in the matter of an impounded case.
Ms. Jellison, you're all we have for this case, so you may proceed.
Good morning, Chief Justice Gants and Associate Justices, and may it please the Court, Eva Jellison on behalf of the minor. With me is Sarah Spofford, who was counsel for the minor at the Section 35 hearing. I want to start by acknowledging what I'm sure is on everyone's mind in a case like this, that Massachusetts is in the midst of a devastating opioid crisis. And I can't imagine how difficult it is to be the parent of a child with substance use issues. Section 35 cases are extremely difficult. Section 35, however, by its terms and due to the fact that it interferes with the fundamental right to be free from physical restraint, must have a limited use. And it must have a use that, in the most extreme cases where a temporary life-saving hold is necessary. Especially in juvenile cases, it has to play an even more limited role because there are robust options for addressing substance use in children, such as a child requiring assistance case. And it must play a limited role because Section 35 commitments, it would seem, are perhaps more harmful for children than they even are for adults.
But the inquiry is fact-specific, so why doesn't the statute, by definition, take into account developmentally difficult transitions and decisions that a juvenile might have? I expect when Judge Oker was looking at this, she had in mind all of those issues that we need to be concerned about when you're dealing with the juvenile.
So this case especially, I think if you read the record, there are many instances where the evidence about the juvenile's behavior were things that are really, they're adolescent specific. These are things that many typical adolescents do: missing curfew, hanging out with inappropriate friends, being verbally combative.
So maybe the standard wasn't met. I mean,
the standard wasn't met in this case.
So that's a reasonable argument. That's a very reasonable argument. What I'm saying is, as far as creating a different standard for juveniles, I'm asking you, since the inquiry by definition is fact-specific, why do we need a different standard for juveniles? Of course you're going to be sensitive to the fact that 16-year-olds make decisions that are typical of 16-year-olds.
So I think that even this court in Diachenko has found that youth is constitutionally relevant. And I think here, as a matter of procedural due process, and if you look to JR versus Parham in the United States Supreme Court, they were dealing with a juvenile mental illness commitment. And what the court said there is that the process that is constitutionally due cannot be divorced from the nature of the ultimate decision that is being made. So where we're dealing specifically with juveniles, I would say that there actually is a matter of due process, as a matter to get to that touchstone of accurate and reliable determination that we're looking for. You have to specifically consider the youth's development. And whether or not that happened in this case, I don't know, because there are no findings on the record that would suggest that it did.
Yeah, but there's a lot of discussion here. This isn't sort of typical, teenage, staying out late behavior. This is, I mean, he's overdosed in the past. They're finding he's got some kind of Xanax that's a waste form of Xanax. His mother's finding him every night with the stuff. I mean, there's clear, excessive use of substances here. And he's in a recovery school because he's already had all kinds of problems. I mean, when you actually read the record, this is not typical juvenile behavior.
I think that some of the behavior is typical juvenile behavior, and then there is certainly a substance use issue here.
A huge substance issue. I mean, we're sort of ignoring the record here. I mean, I read through the transcripts because I was worried about just what you raised, but then I see, a kid who's really on the, in danger here from alcohol and substance abuse, and she's worried about overdose for good reason. So
I think if you read the record very carefully,
I am.
there are a number of instances that you're talking about that would be concerning, but there aren't a lot of specifics, and this is really to the sufficiency issue, but there really aren't a lot of specifics about when exactly that behavior was occurring, how frequently she was finding different substances on his person. The last overdose was a number of years
How
ago.
about, all right, when is the last time you had knowledge of him using substances? How recently? He just used yesterday. I mean, you know, it's.
Right, and in the cases like GP and AM at the appeals court, they were talking about people who had longstanding opioid addiction issues. But in both of those cases, they found that the standard for Section 35, which is very specific, and this is about taking away someone's fundamental right to be free from physical restraint, needs to be very narrow, and the evidence needs to be very specific. So there were certainly concerns about those people who were struggling with opioid addiction, and there are certainly concerns about this juvenile that was struggling with Xanax addiction or Xanax abuse. I'm not sure if Xanax is actually addictive because there was no testimony about the symptoms of Xanax use or what the type of behavior that someone would engage in if they were abusing Xanax.
Wasn't it the adulterated Xanax that was?
Sorry, say that again.
The adulterated Xanax was the medical issue. The problem was the tainted Xanax.
So there's one piece of evidence about the adulterated Xanax. At some time in the
That would
past,
cause a physical harm, right? That could cause that could cause physical harm. Right?
presumably yes, but there was one piece of evidence presented in front of Judge Oker about the lace Xanax, and that had to do with a test that she had done, that the mother had done months before. There was no evidence that the juvenile had any laced Xanax at the time or was using laced Xanax at the time of the hearing. Now, that's the record that we have before us. Temporarily, this was not connected, and I'd remind the court that Section 35 has an imminence requirement. It has to be imminent that the person will harm themselves, harm another, or suffer very substantial risk of harm. So where we have kind of stale evidence about use in the past, which I think existed in GP and AM as well, there are serious concerns for this person, but the court saw fit to say that the order of commitment was inappropriate under the standards for Section 35. So I'm not trying to say that there weren't concerning things going on in this case with this child, and that isn't very, very difficult. But I mean, I think it actually makes sense to turn to the least restrictive alternative argument at this point. And I know in this case, Judge Oker did consider a less restrictive alternative and found that there was not one.
Before you get there,
Absolutely.
you're not challenging the finding that he has a Xanax problem, are you?
I did challenge the finding that he had a Xanax. I challenged the finding that he has a substance use disorder as defined by Section 35. The Section 35 definition is not a medical definition, and it's specific, and I'll read it. It's the chronic or habitual consumption or ingestion of a controlled substance, which I would say we have here, to the extent that such use substantially injures the person's health or substantially interferes with the person's social or economic functioning, or 2, the person has lost power of self-control over the use of such controlled substances or toxic vapors. So where there's a really specific definition of substance use disorder, and the evidence in this case about how frequently he was taking Xanax, or the judge also found that he had an alcohol use disorder, based on the fact that he frequently had open beers in his room. But I don't know that either of those are met in this case where the evidence was not very specific. He was going to school, he was going to this recovery high school, and he was also working at Market Basket. So his social and economic functioning did not seem to be interfered with, and where we don't know how frequently he was using Xanax, I don't think there was any evidence on whether or not he had lost control over such use.
Okay.
I don't think that's
Let's assume we're
Sure.
not, let's assume for the moment we're not persuaded by that.
Absolutely.
Let's turn to the next argument, which is that it has to also be one of the 3 prongs. And one is essentially a suicidal prong, which I guess there's no evidence of.
No evidence.
And the second is that he's going to be a harm to others, of which there's little or no evidence of it. So we're really on the 3rd prong.
Well, is that true? Are we not on the first prong? I thought there was a concern about him overdosing with alcohol and Xanax, that he's, at least on one prior occasion, he was, completely out of it, right?
So
And that he mixes the drugs and the alcohol on a regular basis. So why isn't that the first prong?
So I don't think the evidence was sufficient on that prong. You have to have, the imminence requirement is important here. That has to be that the risk will manifest in a matter of days or weeks rather than months. The last overdose.
She describes drinking yesterday. And when was the last time he's caught with the Xanax on him at school? He just had a fight with another.
30th of January. And this is February 19th.
Go ahead.
So moving on, he had an accidental overdose a number of years ago. It was never specified how many years ago that was. And his mother said that he specifically did not threaten to harm himself. And what the court has held is that it has to be by evidence of threats of or attempts at suicide or serious bodily harm. I don't think we have evidence of threats of or attempts of suicide or serious bodily harm.
Okay, so let's assume that the ball game comes down to the third prong.
Yeah.
A very substantial risk of physical impairment or injury to the person himself is manifested by evidence that such person's judgment is so affected that he's unable to protect himself from the community and that reasonable provision for his protection is not available to the community, and pragmatically that here means the risk of him killing himself by an overdose. So what, in terms of the findings that you say a judge can make in the context of a juvenile, how does that play out? What findings do you say a judge should be making for a juvenile as opposed to an adult with regard to this third prong?
I would suggest that the court hold that juvenile court judges need to make a specific finding about adolescent development and how it affects the juvenile. In this case, Judge Oger questioned the court clinician and the parent and could have perhaps questioned the court clinician on this point and made a specific finding. I don't have a bright line as to, adolescents who are engaging in behavior that is typical of adolescents can never be found to have a substance use disorder or can never be found to be at risk of harm that would require a Section 35 commitment. But I would ask for a finding from the juvenile court judges, an explicit finding, to know that there has been consideration of the stage of brain development as well as any substance use.
But doesn't the brain development argument go the other way in that it shows that the brain is still developing and it's not mature, and so the juvenile can't make good decisions? I mean, how does that help you really?
I think in the context of an involuntary commitment, a restraint of liberty, if you are confining children because they're making typical adolescent decisions, the state should not be able to confine children for making typical adolescent decisions. There has to be more. There has to be a real risk from substance use, especially under the statute.
And how would you quantify that risk? How would you, imagine we could take this case, the facts that we have in this case, and you were on the other side, you just wanted to add a few more facts or one more fact to get it over the rail for this section. What would you add?
Which way, to make it less like, to make him not committed or
to make
committed?
it to meet the standard?
So there are a couple things that would have been helpful to see here. I think a link between Xanax and any particular behavior. I have no idea what Xanax use and abuse looks like from this transcript. And I'm not an expert, and I know the court clinician may be, and maybe there could have been more help there as to what the symptoms of Xanax use look like, so that we could say, this seems like typical adolescent behavior, this doesn't. I can point the court to, there's a case that the AG attached to their brief that is about an 18-year-old with severe mental illness concerns. And the appellate division there parsed it out. They found that the mental illness concerns were a greater contributing factor to the concerning behavior, and found that the juvenile did not have, or not a juvenile, sorry, 18, did not have a substance use disorder. And that was a really fact-specific inquiry, and it's meant to be a really fact-specific inquiry, but I think it's important to consider where you have a juvenile and where you have this typical behavior, that you're not committing a child for being a child.
Your concern about the petitioner and appeal, is that really driven by how long the appeals take, and if it takes too long, it's like there's no appeal?
In part, it seemed as if the appeals court was concerned with giving the petitioner and a pro se petitioner enough time to respond to this appeal, so I think it factored into how long it took the appeals court to rule on the motion to expedite.
And I assume that, to the extent you've looked at data, that the appellate division of the district court, the time for review is quicker than in the
Shorter.
appeals court.
Yeah, typically shorter. So in terms of the expedited appeal, I would ask.
Before you leave this,
Yes.
back to the chief's question about, like, the third prong and least restrictive alternative. Doesn't it matter that the mother is the person taking care of the child, and she's the one bringing the kid in, saying, I can't keep him safe? So isn't that a classic third prong, less restrictive alternative issue?
Yes, I think the mother's testimony about what she's able to do would be relevant to that consideration.
So, I mean, how do you get less restrictive than, how do you, in Justice Cypher's example, adding one more fact, here we've got a kid who overdosed on Xanax and alcohol. Mother's worried about the exact same thing happening again. She can't prevent it because he's ignoring her. Isn't this a standard third prong case?
I mean, I think the third prong is certainly the most relevant. I think those factors are relevant, but you have a child who has has agreed and done the intake for this program. He negotiated with his mother a start date. The high school, the recovery high school, said that start date sounded like a good idea. And the only evidence that he wouldn't go to the program was the clinician's sense that he wouldn't go. So I think for this, there was a less restrictive alternative. It was the intensive outpatient program. It would have kept him in school. He had said to the clinician that he felt like the school was a good fit. And I think it would have been less interruptive. But I'll have to say there also could have been a CRA in this case if the mother needed kind of that continuing help from the court, where there could have been jurisdiction in the juvenile court and services provided by the juvenile court. And the CPCS brief covers the CRA component here.
So we have the least restrictive alternative, which you claim is a constitutional requirement, which would apply to all prongs.
Yes,
But if we're in third prong world,
yes.
the statute itself says that that reasonable provision for his protection, the court must find that reasonable provision for his protection is not available in the community.
Yes.
Is that itself a clear and convincing standard, or is the clear and convincing standard more generalized as to third prong? I mean, must the judge make that finding with clear and convincing evidence?
From everything based upon, GP says that Section 35 cases have to be to a clear and convincing evidence standard. I can't imagine why one part of the third prong wouldn't be to a clear and convincing evidence standard.
So your argument essentially is that there was not clear and convincing evidence for the fact that the outpatient program, which he had agreed to go to after school vacation week, was not a reasonable provision for his protection.
Yes.
I mean, wholly
The
apart
judge
from,
should have found by clear and convincing evidence that there was reasonable provision for his protection.
which was the outpatient program.
Yes.
So pragmatically, that means that when the person says they're willing to go, you'd have to wait for the person to go and fail before you could get a 35 on that person.
I don't know that just saying that you're willing to go would be enough. I think we had more here where he actually went to the intake and had negotiated a new start date, and I think that brings it over the line. But perhaps the judge is entitled to make a credibility determination.
Hasn't he failed in those outpatient programs before?
I don't know that that's in the record. I know that he had previous Section 35 commitments.
Okay, well, thank you. We have nobody arguing the other side, so we'll move on to the next case.
Thank you very much.